In this introduction, I want to cover the foundational aspects of public records, focusing on where to find the key data you're looking for. The Clerk of Court and the Controller are your primary sources for this information, typically found through the official records search on their websites. The clerk's site will provide access to a wide range of important data, including surplus funds, court cases, claims filed for surplus funds on tax deed websites, auction data, surplus funds procedures and claim forms, court registries of held monies, and much more. Think of the clerk as your central hub for all the essential data. Start by exploring the clerk's website for the information you need. If it's not available there, it's often because the data doesn't exist for that particular area. In cases where you can't find what you're looking for, a quick search of the county's population can help guide your decision. For counties with populations under 30,000, it's possible there may be fewer foreclosures to work with. When you need specific data, reach out to the Clerk of Court directly. There's no need to contact the tax collector or other offices for this type of information. While the tax collector manages tax bills and certificates, you're interested in surplus funds and ownership data, which are handled by the clerk and assessor. The assessor tracks property sales and values, including owner information, while the clerk maintains data on court cases, surplus funds, and more. For mortgage overages, you'll want to obtain the court registry to see case numbers and the status of any monies. Pre-foreclosure data is managed through auction sites, but once the foreclosure is complete and surplus funds are available, the Clerk of Court is responsible for managing these funds. Some counties, like Orange County, allow direct searches for court registry funds if you have the case number, showing you which cases have available funds. While some clerks may charge a fee for accessing records, it's part of the process if you're committed to doing the work. The remainder of this video will go over the relevant statutes, but it's crucial to first understand the vital role the Clerk of Court plays. Enjoy the video.
All right, team. Today we're talking about public access to records, and this is laid out in sections 119.01 and 119.07 of Florida's statutes. Now, one of the main reasons these laws are so important is that they keep the government open and transparent, and this directly benefits us as finders. The law makes it clear that state, county, and municipal records are open for inspection. This means we have the right to access the information we need to help people recover excess proceeds, whether it's property records, court documents, or auction data. Without this access, our jobs would be a lot harder, because the information we rely on would be locked away. Let's break this down a little more. Section 119.01 sets the tone by establishing that public access is a right in Florida. This isn't just a privilege granted by government agencies, it's a legal requirement. They can't deny us access unless a specific exemption applies, and those exemptions are usually in place to protect things like personal privacy or ongoing investigations. Section 119.07 goes into the specifics of how we can inspect and copy public records. Agencies are required to make these records available for us to view at any reasonable time. This is huge, because it means we're not restricted to certain hours or lengthy processes. The agency has to acknowledge our request and respond in good faith, meaning they need to make an effort to find the records we're asking for, and not just ignore or delay us. But here's the part we really need to pay attention to. If an agency withholds a record, they have to tell us why. They can't just say, no. They need to give us a reason, and that reason has to be backed up by the law. If they claim an exemption, they need to provide a specific citation that explains why they're not releasing the information. This ensures that we, as finders, aren't being denied access without proper justification. Also, if the agency redacts parts of the record, meaning they black out certain information, they still have to give us access to the rest of the document. They can't block the whole thing just because one section is protected. Now, I know some of you might have run into delays, but here's the deal. These statutes make it clear that agencies are supposed to respond to our requests promptly. If they don't, we have legal options to get them to comply, and that's something we'll get into more when we talk about enforcement. In the end, public access to records is what gives us the ability to help homeowners and claimants. It's the foundation of what we do, and these laws are in place to make sure the information stays open and available. Alright, that's our overview on public access. We'll keep building on this, but for now, just remember, these statutes are what make our work possible, and knowing them inside and out is going to help you stay ahead of the game. Let's keep moving forward. We're going to stay focused on what matters most to us as finders: unclaimed property, foreclosures, excess proceeds, and court records. We'll be talking about how these records fit into the law, and whether they're part of any exemptions or not. If they are, it's up to the government to explain why. When it comes to court records and foreclosure filings, not all of this information is wide open. Some parts, like criminal intelligence or ongoing investigations, might be sealed off, but that typically doesn't apply to the work we're doing with excess proceeds or unclaimed property. These court-related records, like foreclosure documents, property liens, or even auction data, are generally available to us, as long as we're not dipping into restricted areas. However, certain parts of those records, like social security numbers or bank account details, will be redacted. That's protected under privacy laws, and that's something we expect when dealing with financial or personal data in court records. This keeps people's sensitive info safe, while still giving us access to what we need to move forward with excess proceeds claims. For unclaimed property, especially when we're dealing with excess funds from a foreclosure sale, those records are usually public. Why? Because they help identify who the rightful owner is, and the whole point is to return the funds to them. The government doesn't hide that information, and it's open to us as long as it doesn't fall under any specific exemption. But if an exemption does apply, like in the case of a sealed court order, the government is required to explain why it's restricted and provide the proper legal citation. This is important because it means you're not just getting a flat no when you request access. There's a specific reason tied to the law. So, the takeaway here is simple. Most of the records we need for foreclosure-related work and excess proceeds are available, with some exceptions for personal information or ongoing investigations. If something is withheld, the government has to justify it and provide a legal reason. And that keeps the system fair, transparent, and useful for what we're doing. Let's keep moving, knowing that understanding exemptions just helps us work smarter and stay compliant. We'll dive deeper into other relevant sections next. Alright team, let's dive into protections for sensitive information under sections 119.105 and 119.0714. In our line of work, we come across all sorts of records, court documents, financial details, even sometimes information about people's personal lives. While most of these records are open to us, it's important to know that there are rules in place to protect certain types of information, especially when it comes to victims of crimes, personal details, and confidential business data. Let's start with section 119.105. This one is straightforward. It says that if we come across confidential information in a police report or other official records, we cannot use that information for commercial solicitation. For example, if someone's been a victim of a crime, and we access that record, we're not allowed to reach out to them or their family for business purposes. It's not just about respecting the law, it's about respecting people's privacy and their right to not be exploited during a tough time. And that applies to third parties too. We can't knowingly share that information with someone else who might want to use it for solicitation. The goal here is to protect people from being taken advantage of when they're vulnerable. Now, let's look at section 119.0714, which adds another layer of protection. This part of the law focuses on court files and official records. While we can access most of the information we need for our work, certain parts of those records, like social security numbers, bank account details, or information about structured settlements, are off limits. These protections keep people's financial information and personal identities safe from exploitation. It's also important to note that victims of crimes, whether it's domestic violence, stalking, or any other kind of violence, have additional protections. If someone files a petition for an injunction, certain information that could identify them stays confidential until the court orders otherwise. This helps keep people safe, especially in sensitive situations. For us as finders, it's crucial to know where these boundaries are. We're out here to help people recover excess proceeds and unclaimed property, but we need to make sure we're doing it the right way, by respecting people's privacy and the limits set by law. So, the key takeaway here is this. While we can access a lot of information to help people, there are clear protections in place for personal and confidential data. And those protections are there to stop the wrong kind of use, like using someone's misfortune for commercial gain. As long as we keep this in mind and stay respectful of these protections, we're not only staying compliant but also doing the right thing for the people we serve. Let's keep our focus on using the information we access in a way that's ethical and beneficial for everyone involved. Auction data is generally not considered part of the protected information under sections 119.105 or 119.0714. Auction data, such as property details, opening bids, and sale results, is typically part of the public record and is often openly accessible since auctions are public events. This type of data doesn't usually fall under the category of sensitive information like social security numbers, financial account details, or personal information of victims of crimes, which are explicitly protected under those sections. Here's why. Auction data is public by nature. Auctions, particularly for properties like foreclosures or tax sales, are public processes. The data from these events, such as the property's value, auction results, and the identity of the winning bidder, are often part of the official public record. Purpose of auction data. The primary purpose of making auction data public is to promote transparency in government and public financial dealings. Since auctions involve public entities, like a county or city, making this information available allows citizens to understand how assets are handled. Distinction from personal information. Auction data is focused on the property rather than the individual. It typically doesn't involve the disclosure of sensitive personal information that would be protected under privacy laws. Even if an individual's name is associated with an auction, such as the original property owner, this is still considered part of the public record because it's tied to legal and financial proceedings. Exceptions for sensitive data. While the auction data itself is public, if any sensitive personal information, such as social security numbers or confidential victim information, were included in those records, that specific data would be protected. But in practice, auction records generally don't include those details. Practical application for your work. Accessing auction data. You're free to access and use auction data in your work as a finder without worrying about the legal protections under sections 119.105 and 119.0714. As long as you're not using any sensitive personal details that may be incidentally included in the broader records. Using auction data responsibly. While auction data is public, it's still important to use it ethically, focusing on helping property owners and claimants recover funds or handle their property, rather than exploiting the data for unrelated commercial purposes. In summary, you're good to access and work with auction data as part of your business, but you should continue to respect the boundaries when dealing with personal or confidential information related to individuals. Lastly, it's very important to note that when a homeowner requests for you not to call them, you should keep your own do not call list and obey the request of the homeowner. Let's move forward onto our next topic. Alright team, let's keep moving with public record maintenance and protection, which we'll cover from sections 119.021 and 119.10. So, here's the deal. Agencies, whether they're state, county, or local, are required by law to maintain and protect public records. And for us as finders, knowing that these records are properly taken care of is crucial to the work we do, because it guarantees that the information we rely on is available, secure, and accurate when we need it. Section 119.021 makes it clear that these agencies have to preserve records in a way that keeps them accessible and safe. That means things like fireproof or waterproof safes, and making sure records are stored in secure locations. This also applies to electronic records, where agencies need to make sure that digital files are properly stored and protected from being tampered with or destroyed. Why is this so important for us? Well, without proper record keeping, we could be missing out on key documents that help us identify excess proceeds or track down unclaimed property. If records are lost, damaged, or poorly maintained, it affects our ability to get the job done. But what happens if an agency or an official doesn't follow these rules? That's where Section 119.10 comes into play. If a public officer, whether it's someone in charge of maintaining the records or someone else in the agency, violates the public records law, they can face some pretty serious consequences. Here's how it breaks down. If it's a simple violation, like not complying with certain aspects of the law, the officer could face a fine of up to $500. But that's just the beginning. If they knowingly violate the law, meaning they intentionally withhold records or refuse to make them available when they're required to, they could be hit with a misdemeanor charge. That's a first-degree misdemeanor, which could lead to criminal penalties. On top of that, they could be suspended or even removed from office. This is a serious message to anyone handling public records: compliance isn't optional. Agencies and officials have a legal duty to keep records safe and make them accessible, and failure to do so comes with real consequences. For us, this is good news. It means that there's a system of accountability in place to make sure records aren't lost, hidden, or improperly destroyed. If there's ever an issue where we feel like records aren't being handled the way they should, we know the law is there to protect our right to access that information, and it holds people responsible if they fail to do their job. In short, record maintenance isn't just about keeping things organized. It's about making sure that the information we need, whether it's court records, foreclosure documents, or financial statements, is available, secure, and reliable. And if an official doesn't do their part, there are legal consequences in place to make sure they face accountability. Let's keep this in mind as we continue working. Knowing that the system is set up to support transparency and accountability helps us stay confident that we'll get what we need, when we need it. Alright team, let's talk about the legal processes and enforcement laid out in sections 119.11 and 119.12. Now, when we're working on claims related to excess proceeds or unclaimed property, we might occasionally run into situations where getting the records we need doesn't go as smoothly as we'd like. It's important to remember that government agencies have a lot going on, and sometimes things just take longer than expected. But here's the thing. We need to be kind and patient with the government workers we deal with. They're doing their job, and we're all just trying to work within the system. That said, the law has some strong protections for us if there's ever an issue. If an agency is unlawfully withholding records, we have the option to take legal action, and here's where things work in our favor. The courts treat these cases with priority, meaning they get fast-tracked. The court will schedule an immediate hearing, giving the case priority over other cases, so we're not left waiting for months. Once a court issues an order requiring the agency to release the records, the agency has to comply within 48 hours, unless the court says otherwise. That's a pretty tight window, and it means that we can move forward quickly once the court sides with us. Now, if the agency fails to comply within that time frame, the law allows the court to award attorney fees to us, the complainants. This helps cover the cost of enforcing our rights. But here's the key. We don't want to jump straight to legal action unless we absolutely have to. Most government workers are there to help, and by being kind, professional, and patient, we can often resolve issues without having to go to court. However, it's worth mentioning that there are protections in place to prevent people from filing frivolous lawsuits. If someone files a lawsuit just to cause trouble or for reasons that don't hold up under the law, the court can turn around and make them pay the agency's legal fees. So, it's always best to work with the agency first, and only use legal action as a last resort if you're sure the law is on your side. In short, these sections are here to make sure we can enforce our rights to public records access, but always remember, a little kindness goes a long way. Most of the time, you'll get what you need just by being polite and working with the agency. When things don't go as planned, the law has our back, but let's save those legal moves for when we really need them. Let's keep this approach in mind as we go forward. We'll be more effective, and we'll build stronger relationships with the people we work with. Alright team, let's keep it rolling and dive into our next topic. Review and repeal of exemptions, which is covered under Section 119.15. Here's something really important to understand about how Florida handles exemptions to public records access. Florida is known for its strong commitment to transparency, but it also recognizes that some information needs to be kept private, whether it's for privacy reasons, security, or to protect sensitive information. But, and this is key, these exemptions aren't permanent. They're put under the microscope regularly to make sure they still make sense. That's where Section 119.15, also known as the Open Government Sunset Review Act, comes in. This law says that every 5 years, any new or substantially changed exemption is set to expire, unless the legislature steps in to review it and decides it's still necessary. This keeps the system balanced, making sure exemptions aren't just sitting there forever, covering up information that could be important for us to access, especially when it comes to things like court records, foreclosures, or excess proceeds data. So, what's the point of these regular reviews? The goal is to make sure that every exemption serves a clear public purpose. It's not enough to say, this information needs to be private. The government has to ask questions like, does this exemption allow the state or local government to run more efficiently? Does it protect sensitive personal information, like someone's identity or financial details, from being exploited? Does it safeguard confidential business information that would hurt a company's competitive edge if it were made public? If the exemption doesn't pass the test, it gets repealed. This means the information would become public again, ensuring that the state stays true to its commitment to open government. For us, as finders working with excess proceeds, unclaimed property, and court records, this is a big deal. It means that exemptions that might block certain information from being available to us are always under review. We can trust that if an exemption exists, it's only there because it truly needs to be, whether it's protecting someone's safety or business integrity. But here's the flip side, if the exemption is justified, it can be renewed for another 5 years. This process ensures that exemptions stay narrow, and they don't go beyond what's necessary. So, if there's a valid reason to keep something confidential, the law ensures it stays that way. The review process is also an opportunity for public input. This means if there's an exemption that's no longer serving its purpose, it can be challenged and potentially repealed. That's how Florida keeps the balance between openness and privacy in check. In short, this system guarantees that exemptions are only in place for as long as they're justified. It prevents information from being hidden indefinitely and makes sure that transparency is the priority, with only necessary exceptions. For us, this is a reminder to stay informed. If certain records we're looking for are exempt, it's worth checking to see if that exemption is up for review. Things change, and exemptions can expire, opening up access to more of the information we need. So, as we continue our work, let's remember that nothing stays hidden forever unless it truly needs to be. This system of review ensures that we always have access to as much information as possible while still respecting privacy and security where it counts.